appeal in the matter of Southern Pacific Securities plc against Walker and another.
Mr. Morley.
Please, Your Lordships. In this matter, I appear for Mr. and Mrs. Walker, with my known friends Mr. Salter and Mr. Richardson. My known friends Mr. Elliott and Mr. Edwards appear for Southern Pacific Securities.
Thank you.
My Lords, this is, as far as I am aware, the first case in which what might be termed the arcana of the Consumer Credit Act 1974 and its derivative regulations have come before this court for decision as to the meaning of the Act and the regulations, as opposed to whether they are or are not compliant with the Convention on Human Rights. Your Lordships will have seen that the case turns on whether or not the loan agreement between Southern Pacific and the Walkers was compliant with the Consumer Credit Act and the regulations, in particular the Agreements Regulations 1983, and if it was not compliant with them, whether it was so seriously not compliant as to render the agreement wholly unenforceable under the provisions of section 127(3) of the Consumer Credit Act. Now, it was the provisions of section 127(3) which led the whole question of unenforceability to be considered by the House of Lords in Wilson and First County Trust, because in the Court of Appeal in that case, as your Lordships will know, the Court of Appeal came to the conclusion that the First County's agreement was not compliant with the Act and the regulations, and in particular it failed to contain the vital information required by Schedule 6 to the 1983 regulations, in that it did not accurately state the total credit. The result of that was, of course, that the agreement, and indeed all agreements in that form, were unenforceable. And the Court of Appeal, of its own motion, considered that that rather draconian consequence ought to be considered under the Convention, and it was considered, first of all, by the Court of Appeal that decided that this was not compatible with the European Convention, and then by the House of Lords, which decided that it was compatible, and in any event, the 1974 Act was not, in effect, justiciable under the Human Rights Act because of its lengthy predating of the human rights.
But we don't get any assistance, I think, from the House of Lords speeches on the issue we're dealing with today.
No, my Lords, they took it as a given that the decision of the Court of Appeal that the agreement was wholly unenforceable was correct.
Yes.
And they simply considered the consequences of that. As your Lordships may also know, that having established before the House of Lords that section 127(3) and indeed subsection 4, which is a similar provision with regard to cancelable agreements, was compatible with the Convention, Parliament then decided to repeal subsections 3 and 4, which they did by section 15 of the Consumer Credit Act 2006, which came into effect in respect of agreements made on and after the 6th of April 2007. So as of today, no agreement that has been written by any lender since the 6th of April 2007 can be wholly unenforceable in all circumstances. If they are non-compliant, they are all now enforceable with the leave of the court under section 127, subsection 1. My Lords, the purpose, as we say in our written case, the purpose behind the Consumer Credit Act, and indeed the purpose that was identified by the Crowther Committee that provided the background for the Act, was that agreements should be transparent, that the debtor should be given precise and accurate information as to what the financial provisions and consequences of the agreement might be. The Act and the subsequent regulations, including the Total Charge for Credit Regulations 1980 and the Agreements Regulations 1983, created a new concept, the annual percentage rate of charge. Now, the annual percentage rate of charge was intended to deal with the fact that interest expressed simply as a base figure of interest would not represent the true cost of borrowing in the event that the agreement was, as most agreements were and are, an agreement where the capital repayment was amortised over the period of the agreement. Clearly, if I borrow £10,000, agree to pay £1,000 interest, and agree to pay the whole lot after 1 year, that is interest at 10%. There's no problem about that. But if I pay off the 10,000 plus the 1,000 in 12 monthly instalments, then of course I'm repaying the capital by bits and bobs over the next 12 months, and therefore the true interest rate rises.
We see that very clearly, I think, in this agreement, don't we, where the boxes are filled. Although you'll no doubt come to explain this, the APR is a figure attributed to A and B, but not to the total figure shown in E.
My Lord, I shall be coming to that. That is one of the many problems that Southern Pacific faces with this agreement.
Yes.
My Lord, may I, before coming to the niceties of it, deal with a more general point? In a number of these cases, of which, as I say, this is the first actually to reach your Lordship's court, we are dealing not with simply an agreement. Of course, though your Lordships are seized of the agreement between the Walkers and Southern Pacific, we're obviously dealing with an agreement which will have been used on several occasions, perhaps even thousands or tens of thousands of occasions. Consequently, it is a right to say in all these cases that an adverse decision by a court, particularly a decision that the agreement is wholly unenforceable under section 127.3, will have serious consequences for the lender. That is undoubtedly the case, and one which I do not shirk from. But the fact of the matter, of course, is if we are right, then sadly so much the worse for the lender. If we're wrong, of course, his agreements are enforceable and will be enforced. But, my lords, there is, if I may say so with respect, there is no, as it were, residual discretion in the court. If we are right, this agreement is struck down, and if this strikes down 10,000 other agreements, then that is the natural consequence. Any sympathy that there might be for the lender is sympathy which is, as it were, extrajudicial and not part of the decision.
Well, I think you can take it that we'll approach the case strictly according to the meaning of the statutes and regulations.
Of course. But, my lords, I mention that because my learned friends say, quite reasonably, as all lenders say in these circumstances, well, look, we've done our best to comply with the law, and we have, if we have made a mistake, it is because we have acted in a particular way, and we thought we were right. In Wilson and First County, the finance company thought very carefully about what it was doing, and it said to itself, in accordance with what might be termed logic, common sense and the common law, we are charging this lender an extra £250. We are lending her the £250. Therefore, we will treat the £250 as credit. Now, on the terms of the Wilson agreement, the Court of Appeal came to a decision which may, and we shall obviously have to discuss whether it is or is not a correct decision, but a decision which I think it could fairly be described as counterintuitive. It may well be right under the wording of the Act, but it was certainly counterintuitive. And therefore, First County Trust could legitimately say, I think, well, we did what we thought was obviously right, it turns out that we're wrong.
Well, I think it would help if we got down to the detail that you want to us to examine. I mean,
well,
where do we start? Do we look at the agreement, or do we look at the Act or the regulations?
My lords, may I just...
Can I just put one point to you?
Yes,
I mean, all right, good faith is no answer, but when you're construing the meaning of a statute, you're entitled to have some regard to the consequences. And if the draconian effect is one which applies in a limited class of circumstances, there might, in case of ambiguity, be an inclination to maintain the limits quite tight if there was a choice, if it's ambiguous.
Lord, if it's ambiguous, I would entirely agree with your Lordship to that extent. But if it's ambiguous,
Yes, well,
Then, my lords, may I actually take that point and just develop it very slightly? If it is ambiguous, then the first guide we would submit that your lordship should follow is to look at the purpose of the Act. And if the purpose of the Act is the protection of the consumer and ensuring that the consumer is given full information about the agreement, then any ambiguity we would submit would be resolved in favour of the consumer and not in favour of the lender.
Why isn't the judicial discretion good enough to cater for that? The alternative to the strict construction would be a situation where the court had a discretion according to the justice of the case, and that would cater for all those points.
My lords, with respect, no, in this case, because if the agreement correctly states the amount of the credit and the amount of the charge for credit, then no discretion is required. It's a fully enforceable agreement. We would not need to go to the court and say, we are non-compliant, but solvable by an order of the court. This is, I'm afraid, a Manichaean choice. Either this is non-compliant under Schedule 6, in which case the agreement is unenforceable in all circumstances, or it is compliant, in which case it is enforceable and without leave of the court. So, my lords, to that extent, one cannot, as it were, use a tertium quid and say, oh well, if it avoids, as it might be, the capital charge, nonetheless there is a discretion on the lesser charge because it's all or nothing on Schedule 6, my lords. So that I think is not the case. My lords, may I just briefly conclude what I was saying about the position of Southern Pacific. Southern Pacific undoubtedly claimed, and I'm sure correctly claimed, that in drafting its agreement, it was attempting to follow what the Court of Appeal had said in Wilson. But the effect of doing so was to create an agreement, and indeed quite consciously to create an agreement, which did not state on its face that the broker's fee, which was being treated as a charge for credit, itself carried interest which nowhere appears on the face of the document. And I say the face of the document because the face of the document is what matters.
There is a condition at a lending condition, isn't there? Lending condition 15.
My lord, yes.
But you're saying the face is what you see in the boxes on the front page.
The face of the document is what is crucial to the enforceability or otherwise of the agreement.
Where does the face of the... we've got it on 2 pages. Which is part of the face of the document and which is not part of the face of the document?
Lord, Your Lordship, it's tab 6 of the appendix. Lord, your Lordships should, your Lordships may not have a copy. I have a copy of the actual document, which has the first page with the heading Credit Agreement as the front, and the lending conditions on the back.
Yes, I have a single sheet.
It's a single sheet. It's a single sheet document.
But the face of the document includes the notes, does it?
Lord, the answer is yes, it does, but that's not what is vital for the purposes of the agreements regulation. What is vital for the purposes of the agreements regulations are the boxes, because the boxes and their contents are what are prescribed by the regulations, and it is the boxes and their contents which determine the enforceability or otherwise of the agreement. For example, if one looks at the bottom, important information, you should read this carefully, and so on. Nothing turns on this particular case, but that box is prescribed, and different boxes are prescribed for different agreements. And if by inadvertence you put the wrong box in, then your agreement becomes immediately unenforceable, save with leave of the court. It's not, as it were, a hanging matter, but it is nonetheless so that if I were to describe the regulations as prescriptive, I'm in fact understating rather than overstating the way in which they operate. And my lords, the whole thinking behind them is that the information is given in precisely the way that the agreements dictate and not otherwise.
Sorry, I mean, we ignored the sentence payments. On the first page, you must repay the amount of credit together with any amounts financed under this agreement with interest by making the monthly payment.
Lord, one doesn't ignore it because that is relevant, that may be relevant or irrelevant to how you read the Act. It is completely irrelevant to whether or not it is compliant with the regulations.
But it's relevant to what is shown on the face of the document because it's part of the face of the document.
Lord,
So the face of the document tells you that the amount financed is 18,375 and interest calculated on that figure. Is that right?
yes, I fully agree. But, my lords, that's not, of course, what those notes are, as it were, nothing to the point, because the Act is quite clear as to what you do and do not include in the principal boxes or principal sections.
Of course, the Act is something different, but apart from the possible glitch referred to by my Lord Hope about the APR being applicable to the credit shown in both A and B, if you leave that on one side, the position is perfectly clear on the face of the document, including the note. I mean, nobody could be confused about what they had to pay or when they had to pay it or anything like that.
Well, my lord, nobody could be confused as to what they
Now,
have.
you may say that's irrelevant.
My lord, no one be confused as to what they have to pay because it says monthly payment 244.45 or 46. Sorry, bad copy. Now, that is quite clear. My lord, the point here is not whether or not what the borrower has to pay is clear on the face of the document, certainly as read by a lawyer. The point is whether the document is compliant with the regulations.
And you're going to show us the regulations now, are you?
My lord, if I may briefly,
Very, very
before
helpful.
turning...
We're talking sort of shadow boxing at the moment. I'd very much like to have the regulations set out in front of us so we know exactly what we're looking at.
Certainly, my lord. My lord, before I do that, however, may we look at the financial matters box, because that is the box to which the regulations are going to apply.
Well, we've all read it several times, and we've had your cases, and like my colleagues, I feel it would be helpful to have the framework.
But before turning to the regulations, my lord, can we look at line E, total amount financed? Now, total amount financed is not a term of art. It is not a term that appears in the Act, and it is not, when we turn to the regulations, a term that appears in the regulations. My lords, when I turn to the regulations, which I shall do very shortly, it is clear from the regulations that the regulations do not permit you to put in a piece of information which the regulations themselves do not prescribe. And I shall make that...
Startling submission. You would have to persuade us about that. You say they're prohibiting what we see in E?
My lords, yes, and I'll take your lordship. I will now give your lordships chapter and verse. Your lordships will find the regulations set out in an off-print from Guest and Lloyd.
Just a matter of interest, which bundle should we use? We seem to have two
My lords, I'm sorry.
overlapping
the purple
bundles.
bundle. There are overlapping bundles, my lords. The fuller bundle is the purple bundle, and unless it causes your lordships inconvenience, I will work from the purple bundle. I'm sorry, I should have made that clear.
And which tab would you like us to look at
It is
first?
tab 4 of the purple bundle. My lords, these regulations are not particularly easy to follow, not least of which because in the form that we have them here, they and indeed in all the textbooks, they print the old version of the regulations and the new version of the regulations. As your lordships obviously will have seen from the papers, we are dealing with the old version of the regulations. The new one came into force on the 31st of May 2005, which postdates this agreement. So the agreement has to comply with what I might term the old regulations. Your lordships will see the pages are not, as it were, externally numbered. So about 6 pages in, we have there, page 3111, or side paragraph 3217.
Yes. So the old ones are italicised, is that how?
The old ones are italicised, yes, I should go back to that. Regulation 2.1, subject to paragraphs 2 and 7a below, documents embodying regulating consumer credit agreements other than modifying agreements shall contain the information set out in column 2 of Schedule 1 to these regulations insofar as it relates to the type of agreement referred to in column 1. And then paragraph 2, subparagraph 2, or paragraph 2 rather, deals with making assumptions, which doesn't apply here. Then the cancelable agreements are dealt with in 3. Now, Regulation 2.4 is quite important. Subject to paragraph 5 below, the information about financial and related particulars set out in paragraphs 3 to 19 of Schedule 1 to these regulations, and also the statements of protection and remedies available to debtors under the Act specified in Forms 5, 7 and 9 of Part 1 of Schedule 2 shall be shown together as a whole in documents embodying regulated consumer credit agreements and not interspersed with other information apart from subtotals of total amounts and cross-references to terms of the agreement. So, provided that the statements need not be shown together as a whole with the said information about financial related particulars, if a reference to those statements is shown together with the said information about financial and related particulars. My Lords, Lordships are not concerned with the statements specified in Form 5, 7 and 9 of Part 1. They're the statements of rights and remedies. No question arises under those. They're the boxes at the bottom of the front page to which I referred your Lordships. Your Lordships, I don't think, are concerned with paragraph 5, which are restricted use debtor-creditor supplier agreements to finance acquisition of goods, services or land. Essentially what that says is if you've got a list of items covered by one hire purchase agreement, you can show them as a list and then total them up at the bottom, as it were. Then subparagraph 6, the APR referred to in paragraphs 15 to 17 of Schedule 1 shall in documents embodying regulated consumer credit agreements, then other than ones in the exemption regulations, be denoted as, and then it says how you should set it out. Subject to paragraph 7a below, documents embodying regulated consumer credit agreements, other than exempt ones, shall contain a signature box, and that's the signature box. Then 7a doesn't, I think, concern us. That's to do with payment protection insurance, PPI, which we're not concerned with here. So, my Lords, that is Regulation 2 of the old regulations. My Lords, coming back to Regulation, to paragraph 4. Paragraph 4 effectively requires you to have, whether as a box or anything else, a discrete part of the agreement which contains the financial and related particulars set out in paragraphs 3 to 19 of Schedule 1. My Lords, Schedule 1 my Lords, it's again very difficult to follow. Schedule 1 starts at page 3135 at the bottom. And in fact, one can turn to 3136/1, which is paragraphs 3 to 9, or starts paragraphs 3 to 19. Paragraphs.
Sorry, I haven't quite got there. I got to
3136/1 should start with paragraph 3 of the schedule.
Yes, I have that. Thank you.
My Lords, one can, I hope, go through them fairly quickly. Paragraph 3 is restricted use debtor-creditor supplier agreements. This isn't. And paragraph 4 is agreements within paragraph 3, so that doesn't apply. Paragraph 5 concerns advance payments. That again is not applicable here, but that is part of the information. Paragraph 6 applies to restricted use debtor creditor supplier agreements within paragraph 3, so that doesn't apply. But in paragraph 7, agreements for fixed sum credit not falling within paragraph 3, the amount of credit to be provided under the agreement. Lord, that is a term of art, and we shall return to it in a moment. My Lord, paragraph 8 is agreements for running account credit, which this is not. 8A Lord, 8A is not in the old, this is somewhat confusing, 8A was not in the old regulations. 8A and 8B come in 2005. So although 8, it's very confusing in this, and indeed I have to say in Professor Good's work as well, getting the old and the new...
So it should be in italics.
Yes. Lord, no. The problem that... May I
The other bit should be in
my Lord, may I explain the problems?
It says that there is a footnote, there is a note, isn't
Yes,
It does
the
actually say
modus
so.
operandi has been generally where the old regulation has gone and replaced by a new regulation, the old regulation is in italic and the new regulation in ordinary typeface. Unfortunately, we have the problem that a number of paragraphs of the schedule remain unchanged.
Well, why don't we just focus on the ones that are relevant?
My Lord,
assume all the other ones are
that's right,
irrelevant.
but I'm simply dealing with
So why don't you just identify which are relevant? and then we'll just
italicised
assume the rest
points.
have got nothing
Well,
to
my Lords, I'm much advised. Right. Paragraph 9 agreements for fixed sum credit, and then it takes out a number of matters, the total charge for credit with or without a list of its constituent parts, and the mirror that is agreements under 10.
Sorry, are you saying 9 is relevant or not?
My Lord, in this case, 10 is relevant.
So you don't worry about 9.
10 is the sweep up. It's either a 9 or a 10. This one is a 10. Paragraph 10.
So at the moment we've got in play, we've got 7 and 10.
Lord, yes. This has been replaced, so we look at the italicised version. Agreements for running account credit and fixed sum credit falling within sections paragraph 9.8c, so it's the second of those. The rate of interest on the credit to be provided under the agreement, the total amount of other charges included in the total charge for credit in relation to the credit to be provided under the agreement, except that where any such charge cannot be stated as an amount, the rate of the charge or the formula in accordance which it may be calculated and the total amount of such other charges shall be shown separately. So the rate of interest is of course self-explanatory. The total amount of other charges is a matter to which we may have to return as being one of some controversy. But that, sorry.
You've abandoned it in your appeal.
My Lord, as a ground of appeal, I quite agree, yes. My Lord, that does need to be will need to be looked at, though there's not a non-compliance argument in this appeal relating to 10. My Lords, paragraph 11 is not relevant. Paragraph 12 applies to all agreements. The timing of repayments to be made under the agreement expressed by reference to one or more of the following, and then that is all set out. Paragraph 13 applies because paragraph 14 does not. Then the amount of each repayment to be made under the agreement expressed as a sum of money or a specified proportion or combination.
Sorry, which you're reading now?
13 at the top of page 3136/8. So that again applies. 14 does not, because 13 does. 14A is new law, not old law. Paragraph 15, all types except for those referred to in paragraph 16 Paragraph 16 does not apply here, so paragraph 15 is the applicable paragraph, the APR. Paragraph 17 doesn't apply. Paragraph 18 applies in this case. Agreements under which the rate or amount of any item, including the total charge, will or may be varied. A statement indicating that in calculating the APR, no account has been taken of any variation. This is a variable interest agreement, so paragraph 18 applies. And in paragraph 19, there must be a statement indicating the circumstances in which any variation may occur, and where that information is ascertainable at the time the document is presented or sent to the death at the time in which any such variation may occur. My Lord, those are paragraphs 3 to 19, relatively few of which apply in this case. Obviously, the key ones apply in this case, but that is the information which must be shown together as a whole and not interspersed with any other information. Consequently, whether or not if we return to the agreement, total amounts financed is or is not a correct term, total amount financed is at best other information which Regulation 2.4 says shall not be interspersed with the information in paragraphs 3 to 19. So that the point that is being made, perhaps rather laboriously, is that the only way in which a finance company such as Southern Pacific could structure this agreement to achieve the result it says it wishes to achieve is by disregarding paragraph 4 of Regulation 2.
There is a qualification at the end of paragraph 4, isn't there, saying apart from subtotals of total amounts and cross-references to terms of the agreement.
Yes.
Now, is it saved by that? Because
Lord,
looking
not,
at the table...
because it clearly is not a subtotal, it's a grand total. Lord, if the only way in which it would be compliant would be if A, B, C and D were sub-items and E were then described as the amount of credit, because amount of credit is what is required by paragraphs 3 to 19, in particular paragraph
But the amount
7.
of credit is what is in truth the amount of credit, is it, rather than what is stated to be the amount of credit?
Lord,
I mean, your case is that the total amount, the amount of credit is 18,375, is that right?
Yes.
And so if that's right, why
Lord,
isn't it stated as the amount of credit, though not stated expressly to be the amount of credit?
Lord, it must be stated as the amount of credit, and a different figure is stated as the amount of credit.
Well,
there should be only one statement of amount of credit, unless, of course, there are two separate credits, in which case you document it as two separate credits. But in this case, amount of credit is the figure that is required by the by paragraph 7 of Schedule 2, and that's the only amount that you can include in these particulars.
And to find out what that phrase means, we go to the Act, do we?
My Lord,
Section
we shall
9.
go to the Act and look at sections 9.1 and 9.4 of the Act, and also at the total charge for credit regulations. But, my Lord, the amount of credit is in effect the total amount of the credit must be stated as amount of credit in under those terms to comply with Regulation 2 and paragraphs 3 to 19 of Schedule 2.
Is it too simple to think that the amount of the credit is the amount that the borrower receives by way of cheque or whatever it is to accommodate his needs? I mean, that is what he's receiving for his own use. Is that right?
My Lord, well, the answer to that is, I think, the question which your Lordship would have to decide. The amount of credit means credit as defined by section 9.1. Now, in ordinary parlance, if the Act didn't exist, one would say what money is being advanced, answer 18,375, that's the actual loan, that's what they're paying interest on, and that's what should be stated.
But does that follow? Doesn't it just take another example. If they said, we'll lend you £17,500 provided you pay our lawyers' costs, you wouldn't say the lawyers' costs were being advanced to them. You wouldn't say the loan was 18,375. So why do you say it when they say, we'll lend you 17,500? As my lord says, that's what you'll get, either in cash or by having your previous mortgage paid off. And you pay our brokers, is it, or the brokers' administration?
But they're essentially, of course, the borrower's brokers.
Well, are they?
My lord, they're an intermediary.
Well, it doesn't follow they're the borrower's brokers. If you look at the correspondence, it looks as if your clients are writing to Mrs. Amanda Grant at the Finance Centre on page 2, as if she's the other side of the fence. And we know Amanda Grant is the broker.
My lord, my understanding, and I'm correct if I'm wrong, that the brokers here are credit brokers who essentially find loans. They are not, as it were, a vetting agency employed by Southern Pacific. You go to a broker and say, find me a loan, and the broker finds a loan. That's the position, but you provide your broker with the information which your broker then passes on to the finance company or whoever. My lord,
But there's no. This is all evidence you're giving. There's no.
Well, my lord,
there are actually no findings about this, are there?
well, my lord, it's
I mean, there must be some agreement between the lenders
this is the only
and the brokers, because otherwise the lenders wouldn't have paid the brokers.
This is the only information we have, is the information that was put before the Court of Appeal in Mr. Hoff's statement. That's all we have.
Well, the inference is normally that the person who pays engages, or at least that there's some contract. And so the inference is, since you had nothing to do with the payment to these brokers, they were actually being engaged or paid, or at least there's some contract between Southern Pacific and Guardian.
My lord, may I hope, indicate that that is fallacious. My lord, may I ask your lordship, as it were, to forget your lordship's considerable commercial experience as to how brokers operate in, for example, the shipping world.
Well, could we do this, may I suggest, in the light of what is set out in the Statement of Facts and Issues, paragraph 7, because there at least we have something that's agreed, and I don't think Mr. Elliott is departing from what's set out there. I mean, it may not solve entirely Lord Mance's question, but it does at least tell us that the sum in question, which is in box D, was payable to the broker and not payable to your clients.
Oh,
and that's quite
Lord,
important.
that is common ground.
Yes, indeed. Well, it's quite important.
My lord,
It does, however, beg the question of what is an intermediary broker.
well, my lord, the answer to that, it is and it isn't. My lord, whoever it is paid to, it's if it comes within the definition of charge for credit, then it's a charge for credit and treated as a charge for credit. If it in fact is itself a credit, can I come back to the point?
But that may depend upon who the broker is, whose agent he is, and so on. Because if I'm the borrower and I go to a broker, and then the broker finds me a lender, but obviously the broker has to be paid, and since I may be primary on that analysis, I'm primarily liable to pay the broker. So I want the lender to lend me the money to pay not only the amount of the loan, but also the cost of the broker.
Yes.
And then one could say, with a reasonable straight face, that it's part of the credit. If, on the other hand, it is the broker is the lender's broker, then that's much more like the example my lord gave, then it would look to be part of the cost of the credit. Now, an intermediary broker is somewhere in the middle. It appears to me that the answer might depend upon the true relationship between the broker and the parties. But this doesn't seem to be a matter of investigation at all.
Regulation 4 of the 1980 regulations before we debate this.
My lord, may I deal with the questions seriatim and then come to that with your lordship's permission?
Well, I mean, we do need to know what we're looking for before we debate the...
I postpone the question until we've looked at it.
Lord,
the...
may I actually go back to the point made by my Lord Mance in respect of, well, what's the position if you say, I'll lend you the money if you pay the lawyer's fees? Now, the answer to that is twofold. If it's simply, you pay the lawyers, let's say the lawyer's fees are £1,000. We'll lend you this money if you pay our lawyer's fees of £1,000. That is a charge payable to a third party, but it's part of the charge for credit. No problem, it's part of the charge for credit. If, on the other hand, say, you must pay our lawyers £1,000, but we'll lend you the £1,000 to do so and add it to the loan, then that is a credit. Whether or not it needs to be documented as both a credit and a charge for credit is one of the issues your lordships will be asked to decide. But the difference in that case is, one, the money is simply paid as a flat fee. It may well be amortised over a period, but it carries no interest or charge of its own. The other, it actually carries interest, so it is in fact a loan. So coming to the point that was made by my Lord Clerk, that if in fact the money payable to the broker is money which, absent any agreement between everyone, would be money that is due from the for the borrower to the broker, then in effect, as we say is the case here, the lender is lending the borrower the money to pay his broker. My Lord, the answer is that can an item be part of a charge for credit? It can't be both a charge for credit and a credit, as it were, treated in the same as one item. But it can be two items. A charge for credit, i.e. a sum that you have to pay in order to get the basic loan, but it can itself be the subject of a loan. And if the point is made in our written case, assume a Wilson situation where the lender says, I will lend you £5,000, but I will charge you an administration fee of £250. And Mrs. Wilson agrees to that. Now, the £250 is, as their lordships decided in Wilson, a charge for credit. Now, in Wilson, the problem which Wilson did not address, because it didn't need to address, is how do you treat the £250 if that is itself a loan? Assume that Mrs. Wilson, instead of adding it to the first counted loan, had said, fine, I'll pay it direct. But discovering she hasn't got any money, she goes to a third-party lender and says, I will borrow the £250. Here you are, first county, here's the £250 for your administration fee. Now, clearly, it remains part of the charge for credit so far as First County is concerned, but there is a separate loan agreement with a third party for that £250. Now, it would clearly be absurd, both as a matter of common law and indeed as a matter of the Act, if when the lender himself says, right, I will lend you the £250 to pay my administration fee, that is not treated as a credit, bearing in mind the lender proposes to charge interest on that sum.
Well, should we not look at the statute and the regulation? Lord Walker has referred to Regulation 4 of the 1980 regulations, which I suppose have to be read in the light of Section 20 of the Act, to get the language of the statutory material in mind.
My Lord,
Is it not helpful
yes,
to have that?
I would, and before turning to that, however, may I say this, that essential to the whole exercise is identifying the credit. Because until you have identified what the credit is, you cannot identify whether an item is or is not a charge for that credit. Now, a charge for credit isn't to be seen, whether in general or under the 1980 regulations, as something that exists in the abstract. A charge for credit is a charge that you are paying to obtain a discrete and identifiable credit. So that you might have, and indeed you could easily have, an agreement where there are two separate credits with, of course, two separate charges, a higher rate of interest on one than the other.
And Ms. Moore, just before we go, as I'm sure next we are going to go to these other regulations, before you put away the 83 regulations, I mean, I'm no doubt being obtuse, but which, if any, of the provisions or requirements of Schedule 1 to those regulations do you say here is breached?
Paragraph 7.
Paragraph 7.
And my lords...
Wait a minute. Now, paragraph 7 of Schedule 1, is that right?
My lord, let me get that in front.
The amount of the credit to be provided.
Yes.
Right. And I mean, we all know you say it's the larger figure here, and that is that the only requirement of those regulations
Of that schedule?
Yes.
But, Your Lordships, in fact, it would probably be sensible if I would take Lordships immediately to Schedule 6, which is the schedule which, if it applies at all, strikes down this agreement. Your Lordships will find Schedule 6 on page 3168-1. And I'm happy...
Sorry,
3168-1, which is a left-hand page.
Yeah.
Yes. And also, I'm reminded, of course, the repayments are also Schedule 1, but the principal...
Schedule 6.
Schedule 6. Schedule 6 are the prescribed terms. Breach Schedule 6 and your agreement is, or was in those days, wholly unenforceable. My Lords, paragraph 1 does not apply, and paragraph 2 therefore does. A term stating the amount of the credit. So the paragraph 7 requirement from Schedule 2...
1, isn't it?
1, I'm sorry. Wait a minute.
Paragraph 7 of Schedule 1.
Schedule 1, sorry,
Yes.
Schedule 1, yes, I'm sorry, from Schedule 1.
Read with.
From Schedule 1 is made, as it is given this extra force by Schedule 6. Yes. It's the same term, but this one is, it says this term is vital.
Now, am I right in thinking that none of this is in dispute? That's to say, and so that if you're right, and that the amount of the credit is 18,375 and not 17,500, then these provisions have the effect that you've just indicated.
Yes.
So that we're starting from there, really, and the question is whether or not the amount of the credit is 17,500 or not. If it is, good. If it's not, bad, depending on which side you're on.
Are there any other prescribed terms which you say were broken? Can you just take us to them?
I think you said Regulation 2.4, didn't you?
My Lord, my Lord, in Schedule 6.
No, in Schedule 6, yes.
In Schedule
But this
6...
is the relevant schedule for...
5. Paragraph
It's
5.
number 5.
3170.
And which bit of 5 will I...
Consumer credit, terms stating how the debtor is to discharge his obligations under the agreement to make repayments, which may be expressed by reference to combination of any of the following.
They don't say that's broken. It's never been part of their case.
My Lord, no, but your Lord, it was asked which parts of Schedule 6 apply to this agreement, and the answer is paragraph 5 does.
No, but I was actually asking...
It's not our
which
case.
were broken. Yes.
My Lord, I misunderstood.
So the only one you say is broken is a term stating the amount of credit?
Yes.
How does Regulation 2.4 come in then? You say there's something in here which shouldn't have been here. Is that caught up in any way in Schedule 6?
My Lord, the answer is no. The point under Regulation 2.4 is a different point. The point under Regulation 2.4 is this, that the purpose of Regulation 2.4 is to have a discrete part of the agreement which states the items in paragraphs 3 to 19, such as apply, and nothing else. Now, it is a necessary incident of the scheme devised by Southern Pacific that part of the agreement could not comply with 2.4 because the item of total amount financed is not an item for which Schedule 1 provides, and therefore it should not be there. The answer is...
This argument assumes that the amount of the credit itself is correctly stated as 17,500, does it?
My Lord, it doesn't need to. My Lord, that, as it were, area of the agreement can only state one amount of credit. If it states that the amount of credit is 17,500, then that's either correct or it isn't. If it's correct, it's compliant with Schedule 6. If it's incorrect, then the agreement falls. The point about the 18,375 is, we say that is the figure that should be in the total amount of credit
I understand that, but
Lord,
but assuming that
and the total amount
assuming you're
found-
wrong about that, what's Regulation 2.4 got to do with it?
My Lord, there should not be any item in there which says total
Well,
amount
assume they
financed.
shouldn't. What's the
Yes.
effect? What's
the
the
effect?
consequence if you're wrong on the central point?
You say it's an invalid, an improper interspersing of foreign matter.
Yes.
And what's the consequence of that?
My Lord, the consequence is it's non-compliant, but it's enforceable with leave of the court. But, my Lord, the point that is being made is this, that
It's not a prescribed item.
So
it's not a prescribed term, and it's not a matter that has been raised against the enforcement. The point that is being made about this is that it is not simply an impermissible term, it's an impermissible concept for the purposes of the regulations. The regulations assume that there is a total amount of credit, and that is the only credit. It is the sum upon which the charges, if any, are levied, and it is the levying of the charges on that credit which in turn gives the APR.
I understand all that, but if you're wrong and the amount of the credit is 17,500, I still don't understand what Regulation 2.4 has to do with it. You say that there's a breach of it, and that means that the agreement's only enforceable with the leave of the court, do you?
My Lord, yes, but I mean, it's not...
But is that a point that's been taken before?
No, it's not a point that's been taken.
So it's not a point
It's not a
that
point we
affects
take. It's not a point we take.
It would have been a point open to you, but not one that's been taken, is that right? On your analysis.
I gather it was mentioned briefly in front of Judge
But
Halbert,
the point
but
is
not
not
pursued.
live before us.
It's not
So what's
live as a
all this got
ground
to
for
do with the appeal?
enforcement. It is raised in order to show the scheme of the regulations. The scheme of the regulations is that there should be one sum and one sum only appearing as the amount that is provided as a credit. Let's use a neutral term, which is being advanced, which is being lent.
And could you tell us, just for the sake of completeness, though you don't take any point on it, is Schedule 6, Paragraph 4 relevant to this case or not? Are we within one of the exceptions in 9A to C?
My Lord, the answer is it is relevant in that it applies, but it's not alleged that it's breached.
Yeah, thank you very much.
Mr. Maury, I'm sorry. I mean, is there anything... I mean, if you're right about box E, why is it any different to have box D? Should that be there?
My Lord,
Is that,
My
or
Lord-
is that improperly interspersed too?
no, my Lord, because,
Why?
my Lord, if it is part,
Is it a requirement of 3 to 19 of Schedule 1 that you stated?
my Lord, you state all the charges for credit. If it's a charge
I
of
see.
credit, it's
Okay.
correctly stated.
I see.
If it's
Which says will you state charges for credit? Which para?
10, Lord, 10.
10.
It's 10 item 2, isn't it?
It's 10-2, yes,
10
I
to
see.
Schedule 1.
yes.
your real point is that because you're not allowed to intersperse anything which isn't either a charge for credit or credit, therefore whatever in the box appears must be either one of those.
Yes.
Whereas the opposite argument is that E is actually just additional information, and as you say, if there's a breach in including it, you haven't relied on the breach.
In fact, it goes slightly further than additional information because it's in fact...
But as far as I can see, it's irrelevant. You're either taking the point that it's a non-enforceability point or you're not. You're not taking it for some reason best known to you, and given the fact you're not taking it, it's interesting but not really relevant to anything we have to decide. Is that right?
No, my Lord, with respect. Lord, the fact that the breach of paragraph 4 is not relied on as a ground, as it were, for attacking this agreement is one thing. But the point that is being made about Regulation 2.4 is that Regulation 2.4 assumes an exclusive statement of certain matters. And those matters are the matters that are fundamental to the agreement and the only matters that can be included in the agreement, because that's if simply you could go through the motions of filling out a box containing paragraph 3 to 19, but put all the real information somewhere else in the agreement, then the purpose of the Act would be thwarted. The purpose of the Act is that anybody can look at the document and see a line which says amount of credit. That has got to be stated. That's Schedule 6, that's got to be stated. And anybody can look at that and tell instantly, A, what the credit is that's being advanced, and B, whether the agreement is in fact regulated by the 1974 Act. Because, of course, if the amount of the credit is above the financial limits, or below the limits for small agreements, then regulation does not apply. So, my lords, that is why it's a vital figure, because the amount of the credit is central to not only the documenting of the agreement, but to all the other things that flow from it, such as the application of the charge for credit, the calculation of the APR, ultimately the amount of repayments of the credit. So, my lord, that is the crucial figure. That is why it's not simply, as it were, a box-ticking exercise. It is fundamental to the whole concept of regulation of the agreement. Therefore, if you are in fact advancing a larger sum than the amount of credit stated, then you are non-compliant. If you are in fact advancing two sums of money, either of which, if included in a separate document, would be a regulated agreement, as would be the case here, a loan of £875 would be a regulated agreement, then you must document it as two separate credits, because it is two separate credits. So either way, you either say this is one credit for the whole amount, in which case the 18375 has to appear in box A, or you say this is two credits, one for 17.5, one for 875, and you document the charges on the two. It may well be that the 875 has, by operation of the 1980 regulations, to appear as a charge for credit on the main loan and a separate credit, as in the instance, I supposed, where Mrs. Wilson gets a third-party lender to lend her the £250, in fact is asking the same lender to do it, but in a different agreement.
Well, look, a considerable time ago, Lord Walker suggested that you should introduce the 1980 regulations. You just mentioned them.
Yes.
Could we look at them, please? And bear in mind, I suggest the definition in Section 20, subsection 1 of the Act, because we need to have in mind the statutory formula. The statute does use the phrase total charge for credit, doesn't it? And it defines it.
Well, should we start with your Lordship's permission, in tab 1 with section 20?
Yes, please.
Tab 1, section 20, your Lordship will find that this is, it's from Halsbury, it's paginated top left-hand or top right-hand of the page.
Yeah.
It's page 51 of the Halsbury numbering. Lord, I'm not asking your Lordship to look at it at this moment, but this, of course, section 20 is dependent on the crucial definitions of credit and total charge for credit in section 9.
Yes.
The Secretary of State shall make regulations concerning such provisions as appear to him appropriate for determining the true cost to the debtor of the credit provided or to be provided under an actual or prospective consumer credit agreement, total charge for credit. Regulations so made shall prescribe what items are to be treated as entering into the total charge for credit and how their amount is to be ascertained, to the method of calculating the rate of the total charge for credit. And regulations under subsection 1 may provide for the whole or part of the amount payable by the debtor or his relative under any linked transaction to be included in the total charge for credit, whether or not the creditor is a party to the transaction or derives benefit from it. Pausing there, an example under 2 would be where the lender requires as a term of the credit, the borrower to enter into a PPI policy with an insurer. Of course, the payments will be made to the insurer, but as it's a condition of the loan, it's in other words compulsory PPI, then the cost of the insurance is to be written into the total charge for credit.
Could a sum payable to an intermediary broker be included within subsection 2?
Yes. Yes, that is undoubtedly the case. That is why the 875 may well be a charge for credit in this case, but also itself an independent credit. But, my Lord, if we then turn to the total charge for credit regulations. But as I say, with respect, this must be looked at in the context that the total charge for credit regulations can only bite once you have ascertained the credit and the amount of the credit, because it's the charges that you apply to that amount which will give you the APR under the very complicated formula that appears in the total charge for credit regulations. And the actual...
I mean, you're not saying that the APR box is wrongly completed here.
My Lord, that is not part of our case.
Quite. That would be, as I apprehend, a breach of the paragraph 17, or is it, sorry?
Yes, my Lord, but it wouldn't be fatal.
It wouldn't be what?
Yes, 15.
It would be a breach of
15, but it would not be fatal.
15.
It would not be
that's right.
Schedule 6
but
fatal.
It would, I see, but you're not saying it was breached.
Lord, that's not our case.
No.
Lord, the...
Though it was in fact breached. Was it?
My Lord, I'm not saying that it necessarily was. It was breached, unless you take the... if you take the premise that the credit is 17,500, then it's not breached. If the credit is not 17,500, then cede quaestio, then all the figures are wrong.
But I thought the 16% depended upon the 1835. Is that wrong?
Lord, no. As I understand it, and I'll be corrected if I'm wrong, the 16% consists of taking the 17,500 as the credit, and then the charges for credit are 1, the interest, 2, the 875, and as I understand it, 3, the interest on the 875.
Yes.
So that as I understand it, that is the mathematical basis of the 16%.
Yeah.
So that if the 8, so that it's expressed as a charge for credit for the 17,500. Now, if the 17,500 is correctly stated as the total amount of credit, then those calculations follow. But if the total credit is 18,375, then all the figures become wrong, clearly.
I don't understand that. I don't understand why. I mean, the APR applicable to the credit is surely 16% as to both A and B. It also is applicable likewise, in fact, in respect of D.
Lord, no. The APR, well, my Lord, if it did apply to D, then we would be in different territory because then it would be non-compliant. And the reason is this: the APR can only apply to a calculation of the total credit as stated, and the charges for credit as stated on that credit. So that if you took the 18,375 as a credit, then you would apply the interest to that, and that alone, amortise it over the period, and you would get a different APR.
I see.
Yeah. But if you treat it as a charge, it's a different.
Well, my Lord, if the whole thing is a credit, then a single credit, because the 875 is to be treated as a credit rather than a charge for credit, then the only item of charge for credit is the interest. In which case you take your base total credit is 18,375, your interest is whatever it is, 13.8 variable, but that's taken as being unvaried for the purposes of the APR, and you then apply the lovely formula that we find at tab 6, which anybody with a first-class degree in maths from Cambridge, because I'm sure do in half an afternoon, and you then get the APR.
Which would be, in fact, lower.
My Lord, yes, it would in fact be low. It would be, yes, it would be appreciably lower. My Lordship is right. My Lordship obviously have the mathematical skills. Yes, the answer is yes, it would be lower. My Lord, if I can just deal with what maybe somewhat heretical point taken by the response, perhaps really as a throwaway point, that the APR is there as a comparator. The APR is not there as a comparator. The APR is in the agreement, and this is indeed fundamental to the Act and the regulations, in order to tell the customer precisely the precise cost of his borrowing, worked out actuarially according to an extremely complicated formula. So
he can compare it with other bids. Is it not in that sense a comparator?
No, my lord,
I
it's
mean,
not.
the whole point of this is, as you said in opening, the whole point is to achieve transparency so that the consumer can try and shop around and see what's the best deal. Isn't it as simple as that?
No, my lord.
With
respect, not.
That surely is what the Crowther Committee said was the whole point of it, is it not?
My lord, that is one of the functions. It is not the function of including the APR in the agreement. The function of including in the agreement is to tell the customer precisely what that agreement is achieving. Undoubtedly, and when we come to consider, well, not that it's for your lordships, advertising, then undoubtedly in advertising, the APR is a comparator. But of course, with the advertising regulations, the rules concerning statement of the APR are of course different. They are necessarily different because the APR for the purposes of advertisements has to make assumptions, take typical cases and so on and apply similar but not identical criteria. The APR as required by paragraph 15 of Schedule 1 and required by the total charge for credit regulations is the APR for that agreement. By the time it's in the agreement, the borrower has done his comparisons.
Well, I'm not sure I entirely follow that. I'm looking at your rights in the bottom left-hand corner. I mean, the lender has given you a copy of the agreement and you've got time to decide whether or not to go ahead with it. You see what's brought out as the APR. You then realise from looking at other people's advertisements you can get a better rate somewhere else and you could withdraw from this.
My lord, that is if a consequence, it is a secondary consequence. It's not why it's in the agreement regulations. It's in the agreement regulations because it is, both under the Act and under the regulations, it is a statement to the borrower of the true cost of what he is paying for this loan. That's what it's in. That's why it's in. That is the true cost. It may or may not have a secondary purpose of a comparator, though I would respectfully suggest that what your lordship says, though may be theoretically correct, doesn't in fact
That's why he wants to know the true cost.
My lord, he wants to know the true cost because he is entering into that agreement. He may or may not compare it in his mind with what he knows other people are offering, but by the time he gets the agreement, this is to tell the person, just as with the amount of credit, precisely what this agreement is stating.
I mean, the trouble with using these figures as a comparator is that it includes the 875, doesn't it? I had mistakenly supposed it didn't. I thought it was a sort of interest figure, but it isn't. It includes the 875. It doesn't include any repayments of the other capital.
Yes, it does.
It does. It includes the repayment of the 17,500 as well, does it?
Yes.
Yeah, I think so.
All right,
Well, my lord,
that's right, because you said it included the interest on the capital, the 875, and the interest on the 875.
Lord, if I
whereas
may-
I now understand that not to be right.
Yeah,
It includes the loan, it includes the whole thing, does it?
yeah, my lord, yes, if I may correct my learned friend, it doesn't of course include the repayment of the capital. It is the rate of repayment of the capital which governs what the APR is, which is a slightly different concept. If the capital is repayable by monthly instalments, the APR is calculated one way, by quarterly instalments another way, yearly instalments a third way, and if it's payable all one lump sum at the end of the agreement, then the APR and the nominal rate of interest will be identical.
Lord, I rise to my feet with some hesitation. We had prepared a document setting out exactly how the mathematical formula set out as the next to our skeleton has done, showing how the APR operates. I don't know whether that would help. I can do it now or later.
Well, I think when the time comes, you can introduce it.
It's really clearly enough in paragraphs 40 to 43 of your written case. I think.
Lord, but the point that is being made, and I hope I've stressed to your lordship, says that we are not attacking the APR as stated in this agreement if the basic premise that the credit is 17,500 is correct. If it is not correct, then I think it would be equally incontestable that the APR must necessarily be wrong.
Yes.
And as my
Mr.
Lord
Morey,
Man said, lower.
Can I just interject here? You bid in your timetable for 1.5
Lord,
1.5
oh dear,
hours,
yes.
and you're not far off. your full time. Obviously, we're not holding you precisely, but I think it's quite important you make progress. We'd reached section 20, subsection 2.
Yes.
And were we not going to
We were.
fulfil
Tab-
Lord Walker's request that we should look
tab
at
five.
1980
And
regulations?
also, no doubt, we're going to glance at section 9 at some
Lord,
stage.
I was proposing to return to that immediately after looking at the TCC regulations.
Yes, all right. So,
Lords, I am aware, a word to the wise. I hope wise.
so we're at tab 5, looking at the...
Total charge
Sorry,
of
not-
credit
not tab 5.
regulations 1980.
It's not tab 5, it's...
Are we not going to section 9 now? Oh, I see.
Well, my lords, in response to my Lord Walker's suggestion, I'm looking at, your lordships may find it helpful, I think, to start at part 2 of the regulations.
Which tab is this? This is the 1980 regulations.
Tab 5, 3081 of the internal pages numbers. For the Regulation 3. Purposes of the Act, total charge of credit which may be provided under an actual prospective agreement should be the total of the amounts determined as at the date of the making agreement of such of the charges specified in Regulation 4 as apply in relation to the agreement, excluding the amount of charges specified in Regulation 5. 4. Except as provided in Regulation 5, the amounts of the following charges are included in the total charge for credit in relation to an agreement. The total of the interest on the credit which may be provided under the agreement. B. Other charges are any time payable under the transaction by or on behalf of the debtor or relative of his, whether it's a creditor or any person. And then C we could ignore because that is, in fact, PPI insurance. Your lordships will then turn over, I fear, several pages to 3084, which contains a list of items excluded from the total charge of credit. Charge 5.1a is essentially default charges, as is B. Charge C is irrelevant. D. Any charge other than a fee or commission charged by a credit broker, not within subparagraph C above, of a description which relates to services or benefits incidental to the agreement, and also to other services or benefits which may be supplied to the debtor, and which is payable pursuant to an obligation incurred by the debtor under arrangements effected before he applies to enter into the agreement, not being arrangements under which the debtor is bound to enter into any personal credit agreement. Then E isn't relevant, F isn't relevant, G isn't relevant, H isn't relevant, I isn't relevant. Then 2, paragraph 1 has only effect when it deals with subparagraph E, which is essentially, again, care and maintenance of land. So a series of exclusions from the total charge for, in Regulation 4. Now, the problem with 3 and 4 is that because it assumes that you have ascertained the credit, you are enabled by regulations 3, 4 and 5 to say whether a charge is a charge coming within regulation 4 or whether it is a charge prima facie within regulation 4 but excluded by regulation 5. Now, without the ascertainment of the the credit, one cannot tell whether or not this is a charge for the credit or whether this is a separate item in the agreement. Once you have ascertained the credit correctly, then these paragraphs, these regulations, will enable you to say whether or not a fee is payable.
Well, that takes us back to section 9, doesn't
It
it?
takes us back to section 9, to which I shall now return.
Just pausing on regulations 4 and 5, which do you say it falls within?
Lord, it falls, if at all, within 4A, and the question is whether or not it is exempt
4A
under
or 4B?
4D.
It must be B. No, it's not.
Sorry, 4B, I'm
Yes,
sorry,
yes,
4B,
yes.
I'm sorry,
The
I do
question is whether
apologise.
it's exempt
slip
under
of the tongue. 4B.
5D.
As whether or not it's under 5D, clearly it is a charge that fits 1 and 2. The question is it a fee or commission charged by a credit brokerage?
Does it fit 2? Not being arrangements under which the debtor... I see, no, quite right, I get it. So you'd say the question is whether it's a fee or commission charge?
Yes.
Well, it obviously is, isn't it? Well, why isn't it?
Yes, it is. But, and this is the big but, there is no provision in D for the interest charged on the fee or commission. So the fee or the commission is clearly within the exception to D. But D does not legislate one way or the other for any charges made by the lender on that broker's fee or commission.
It doesn't prohibit it. You
Lord-
just say it doesn't provide for it.
My Lord, it doesn't provide for it to be excluded from D. And if it's not excluded from D, then clearly it's caught by D.
But what about the words other than a fee or commission charged by a credit broker?
Lord, yes. The fee or commission is prima facie within paragraph D as being accepted. So paragraph D applies to everything except a fee or commission charged by a credit broker.
So what you're saying is that they have excluded from the exclusion a fee or commission, but they haven't excluded from the exclusion the interest on the fee or commission.
Correct.
The alternative is that it's all part of the fee and commission. If
Well,
that's
my Lord, it isn't, because, of course, the arrangement for paying interest on the fee or commission is an arrangement entered into, in this particular case, between the lender and the borrower for a further loan of money to be made. If the fee or commission is simply paid without any interest, then undoubtedly it's an item, the total charge for credit, and correctly included in such. So if no interest had been charged on the 875, and if line E had not appeared, this would be a perfectly compliant agreement and nobody would be worried. It's the addition of interest to the charge for credit that is the problem.
And to understand the significance of that, we must look at section 9.
To which I'm currently turning and invite your Lordships to do likewise. Your Lordships will find section 9 in tab 1 on internal page 35. My Lord, subsection 1, in this Act, credit includes a cash loan and any other form of financial accommodation. My Lords, come back to financial accommodation in a moment. 2 is not relevant. 3 is not relevant, simply includes hire purchase in the meaning of credit. 4, for the purposes of this Act, an item entering into the total charge for credit shall not be treated as credit, even though time is allowed for its payment. Lord, we say that those 2 sections are designed to create, as it were, a division between credit and charge for credit, dependent upon the incidence of the item concerned. Now, a form of financial accommodation is something upon which the courts have considered in some detail. It's in fact actually quite irrelevant to what your Lordships have to decide. If the 875 is a credit, it's a cash loan, because what is being lent is the sum of £875 to pay the broker's fee. So if it is a credit, it's a cash loan rather
The other
than
way round, if it's a cash loan, it's a credit.
My Lord, if it's a cash loan, it's a credit. Well, the point I was making was, if it is a credit, it comes under, as it were, cash loan rather than under financial accommodation. That's the point I was making.
I mean, this begs the question which we were discussing earlier as to whether, in fact, it is analytically a loan or notionally a loan by the company to your clients at all. I mean, if the company has a contractual obligation, and you mentioned the analogy of the insurance market or the marine market, if the company has a contractual obligation to Guardian to meet this sum, then doesn't fit easily into the idea of a cash loan. It might be financial accommodation if your clients also had a financial obligation to their broker, but I rather doubt whether they did. It's all uncertain, but there's no evidence that they ever agreed or undertook any financial liability or expected to pay anything.
My Lords, I obviously haven't made myself clear. My Lords, what I'm saying, in fact, is much starker than that. What I'm saying is it doesn't matter for this purpose whether the money is paid to the broker in order to discharge a debt of the Walkers, or whether it is paid to the broker simply as an add-on charge for the creditor. So, in other words, applying the Wilson, if it was simply an additional charge which was put onto the agreement and went straight into the pocket of the lender, as was the case in Wilson, nonetheless, that charge is itself being lent to the borrower. Normally, before all these agreements suddenly emerged, the charge was there, documentation fee, administration fee, broker's fee, whatever it is. It was in effect an additional charge made by the lender and went, in most cases, straight into the lender's pocket. In this case, it didn't. But assume that it discharged an obligation of the lender, which is, I accept there's no evidence on it, it would be totally contrary to the way in which consumer credit works, but I accept that it's neutral on that. We haven't any evidence one way or the other. But assume against myself that what Lord Man's posited is correct, that the money in effect discharges an obligation of the lender, therefore the lender is getting the benefit of the money. Nonetheless, it may itself, the basic sum, be a charge for credit, but that charge for credit is then being lent. Clearly lent with interest being charged on it. Now, we would say that that is and must be documented as a cash loan. Now, in Wilson, it was somewhat simplistically taken by the lenders. We're lending you the £250 administration fee. Therefore, there is one loan, £5,250. We will then apply the interest charges to it, which were the only charges then on the agreement, and we will get our APR that way. Now, the Court of Appeal said you cannot do that as it were at two core. You cannot treat the £250, which is clearly a charge for credit, as if it was simply a loan, part of the loan, not part of the charge for credit. The analysis that should have been, well, I'd say should have been made because it didn't need to be made in Wilson. The analysis we say is made is this. The £250 in Wilson and the £875 here is logged as a charge for credit. That would follow from the 1980 regulations. The question is, how do we treat the fact that it bears interest and that interest is going to be payable by the borrowers? And the answer is, it has to be documented. We say, under the regulations, it can only be documented as being a separate transaction whereby a separate sum is lent to discharge sums payable in respect of the first sum. Just as if, in my analogy, Mrs. Wilson or Mr. and Mrs. Walker had gone to a third-party lender and said, lend me the £875, or in the case of Mrs. Wilson, the £250, in order to pay these charges to my principal lender.
So there had to be a second agreement, you say?
My lord, it has to be documented, documented in the same document, but it would have to be documented as a separate loan. Lord,
Is that all because, just to trace it all back to the base of the argument, that when you look at Regulation 5D of the 1980 regulations, the parenthesis doesn't mention interest, just talks about a fee.
my lord, the answer to that is partly yes, but partly more fundamental. It's partly more fundamental because the item is treated as a credit by the lender. He treats the 875 as a credit because he then applies charges to it. And interest is clearly a charge under the 1980 regulations. So he is implying a charge for credit to a sum which in another context is itself a charge for credit. My lords, that is why, this is, we say, is the vice behind charging interest on charges for credit, is that you are in fact creating a second credit and then not documenting it. And it's the absence of documenting it that we say is the vice with this scheme. It would be perfectly possible to document this transparently as two separate credits. You wouldn't need necessarily to have a very elaborate agreement. It's simply you would have a different arrangement of the boxes, and there would be no objection at all, and the regulations would certainly be complied with if the total sum under loans A and B were payable by one set of monthly instalments.
Well, just see if I can fully understand this. You're saying that the key to the problem is that the lender is treating this as it were an item of credit, because
Yes.
he's applying interest to it and there's a payment term and all the rest of it.
Yes.
And he hasn't separately documented that.
Yes.
That would be a criticism which would carry force if it was carried through into the regulations, or to reverse it another way, provided the regulations are complied with. As the Court of Appeal held, I think, your criticism doesn't have any force at all.
Yeah. We say that the only way in which you can comply with the regulations and with Section 9 is by treating everything that is a credit as a credit, and by treating everything that is an item of the total charge for credit as a total charge for credit item and nothing else.
So, as Lord Justice Mummery put it, you strip out the total charges, all the charges, and you're left with the sum which is the subsection 1 credit item.
And also, in our respectful submission, that is putting the cart before the horse. You look to see what is the cash loan, what money is being lent. And the answer in this case is what is being lent is 18,370. The agreement actually says so in impermissible terms, total amount advanced. That is the amount being lent. Now, if that is the amount being lent, that is the credit. That must be stated as the total credit in order to comply with Schedule 1 and Schedule 6. Now,
Sorry, Mr. Morris, the position is that this fee is a charge for credit if it doesn't bear interest, but if it does bear interest, it's no longer a charge for credit, it becomes credit.
Lord, that is, with respect, slightly a simplistic way of putting what I'm putting. What I'm saying is,
Is it
if it's
inaccurate? It may be simplistic.
yes, is the answer.
Why is it inaccurate?
But Lord, if it doesn't bear interest, it's a charge for credit and nothing else. If it bears interest, it is a charge for credit on credit number 1, but it creates credit number 2, which
So
must
you
be
have to
documented as
feature
credit
it
number
twice
2.
in the agreement, do you? Once as a charge for credit,
Yes,
and once as a credit.
yes, my lords.
I see.
My lords, A, that sounds a bit cumbersome. B, it is compliant with the regulations, which would require each credit to be properly stated and the total amount of credit there. Imagine, my lords, that it was in the agreement without any interest on it at all, £875. The day after the agreement is made, Mr and Mrs Walker go to Southern Pacific and say, look, we can't afford this £875 being added to the loan. Sorry, without actually borrowing it. We can't afford to pay it up front. Assume that it was required to be paid up front. We'd like another loan agreement for the £875. Now, you can get a second agreement whereby they are lent £875 for the specific restricted use purpose of paying off the broker's fee, and that agreement runs in tandem with the other. They might even agree to aggregate the monthly payments.
Did we were looking at section 9. Did we ever get as far as subsection 4 of section 9?
My lord, we did, yes. I read say that subsection 4.
You're saying really that everyone in the industry has been getting it wrong for 30 years.
No, my lord.
And that section 9.4 doesn't mean what it says.
Well, my lord, A, we say it does mean what it says, and B, we would be horrified at the suggestion that the industry has been getting it wrong for 30 years. What is before your lordships is a device that was created as a result of, we say, a misunderstanding of Wilson, but certainly it was a device created in order to, I mean, exploit sounds pejorative, but I didn't expect what was perceived to be a situation created by Wilson. I'm putting this quite neutrally, my lord, but the meaning is quite clear. An item entering into the total charge rate shall not be treated as credit. This means that if it is truly an item of a total charge for credit, you cannot treat it as part of the same credit as one.
Well, is it being too simplistic to say, in order to understand subsection 4, you go to regulations, the 1980 regulations, regulation 3, which identifies what the total charge for credit is, and then you look at regulation 5.
So regulation.
This is 1980 regulations, tab 5. And regulation 3 is saying, for the purposes of the Act, okay, the
Yes.
total charge for credit which may be provided shall be, and it tells you what that is. Anything that's in regulation 4 is legitimate. Anything that's in regulation 5 is not, except for the parenthesis in 5D. Now, if it was simply a fee, and there was no question of interest being attached to it, you would accept that was a legitimate charge for credit, which could be put into the total charge for credit and was within section 9, subsection 4.
Yes.
And it's simply the fact that you say
But
interest is not provided for in that parenthesis, that it has to come outside it.
Your point on 5D, paragraph 5, regulation 5D, is an entirely new one, isn't it?
Yes.
It wasn't taken at all below.
It's not in the notice of appeal, it's not in the case.
Because
Lord, it was argued, it was, I'm told by my note, I was not in the Court of Appeal, I'm told by my learned junior that it was argued in the Court of Appeal.
I don't think it's in your written case.
5D was not mentioned so far as argument is concerned in the Court of Appeal.
Oh, Lord, there seems to be a mismatch of memories here. As I was not there, I can't assist your lordships one way or the other.
But I'm just wondering, I mean, if it is an entirely new point, I think we do have to look at 5D because it's quite complicated, of a description which relates to services or benefits incidental to the agreement and also to other services or benefits which may be supplied to the debtor. I mean, it seems to be aimed at some particular collateral transaction, and we don't have the benefit of any views of the judge or the Court of Appeal on the interpretation of 5D.
Lord, my lord, in the Court of before Judge Halbert, he assumed, absent any evidence, that the broker's fee was simply a nice name given by the lenders to money that was going to go straight into their pockets, as with the administration fee in Wilson. There was no evidence that. He simply assumed that this was a charge and therefore part of the...
he called it artificial, so he didn't understand about it at all.
He artificial. Lord, I am the notice. I was referred briefly to the notice of appeal, paragraph 9.
Page?
Tab 1 of the 4 bundle, page 7, I think it is. no, page 6. The page 6, paragraph 9, page 6. And on the right-hand page, under 6, little 5, there will be no further reason for distinction what is deemed to a charge credit and what is excluded under Regulation 5. Lord, so Regulation 5 and the exclusions Regulation 5 were, as it are before the court, and I'm told, and I'm not going to enter into any controversy, were argued before the Court of Appeal. They were not argued before Judge Halbert because we did not then have the evidence that the broker's fee was a genuine fee rather than, as Judge Halbert took it, a sham.
I'm just going to say that I don't think it's very helpful to look at the grounds of appeal because Mr. Elliott says in his written case, paragraph 7, your position as now advanced differs from the markedly from what was set out in that document. And surely we're looking at the case as advanced in the case that you submitted for the purposes of this appeal.
Well, if your lordship's will look.
It's not in the case, though, 5D.
No.
Ah.
Anyway, we're taking up rather a lot of time with this.
We're taking up time unnecessary, and I appreciate that I have overrun by 5 minutes already.
Can I just ask a question on section 9, subsection 4, which
Yes.
Lord Walker mentioned? What is this doing if it is not catering for the present type of situation? Is it really catering for situations where an item entering into the total charge of credit, such as a brokerage fee, is not subject to any interest charge? Because that seems very curious. Seems a very limited role for it.
Oh, my lord,
Where you just allow time for payment.
what it appears...
I'll give you 6 months, no interest. Is it really only dealing with that situation?
Lord, with our respect and full submission, it can only be dealing with that situation. It meant to deal with the argument that there is an item in the total charge for credit which is in effect amortised over the term of the agreement, which was in 1974 the standard means whereby you would deal with it. You would add an administration fee or a similar charge. It would be part of the charge for credit, but it would be paid off with the monthly instalments. So the argument that is countering is the argument, well, because the fee is being paid off in monthly instalments, it is itself credit. My lord, what it's saying is that if that's all that's happening, it is not credit. If it in fact is treated as credit because it is made the subject of a cash loan, then Section 1 applies. It's a question
I mean, it seems to me totally artificial to say that you're loaning the interest. You say it's a loan if only if interest is charged, or is it the interest which is the loan?
Lord, the loan is the £875. The interest on the loan turns the £875 into a credit, albeit a separate credit from the £17,500. So it is a separate credit. That's what we're saying is the moment you lend the £875 to the borrowers, you are necessarily creating a credit because a cash loan is by definition a credit, as my Lord Clerk said. If it's a cash loan, it's a credit. So, my Lords, subsection 4 says that you should not treat it as a credit if even though time is allowed for its payment. What that means is that if it's genuinely a charge for credit, that's to say the basic administration fee, broker's fee and so on, that itself is not to be treated as credit. But if you then go on and in effect in a separate transaction treat it as a new credit, then it's to be treated as a new credit and documented accordingly. We say that it actually makes sense because it tells the borrower precisely what he's doing. He's borrowing sum A, £17,500, £1,500 on which he pays interest and a broker's fee, and he's borrowing sum B, £875, on which he's paying interest only.
But the big difference is that sum A is in his pocket and sum B isn't, and surely the underlying purpose, I mean, is enormously complicated and detailed, and you know a huge amount of it, but just looking at what it's really about, the notion is that the consumer should know how much he's actually going to have left in his pocket, and that's the credit. And what has got to pay to get that in his pocket is the total charge for credit. That's the underlying idea, isn't it? As Lord Hope said right at the beginning of this hearing.
My Lord, I hesitate to disagree, but the answer is no.
Yes, well, I know, because you are so learned on it, Mr. Moore, that you will always have some more complicated way of looking at it.
The answer.
But
The answer-
questions of fact, aren't they?
No.
Really, because what's a charge for credit? It's really a question of fact. The classic charge for credit is the lender who says, I'll only lend you the money if you pay a document fee or an arrangement fee or any other fee you like, but it's just an extra cost of the credit. The thing's more complicated if it is in truth a fee payable to someone else, and if the lender is providing money to pay brokers, certainly if it's the borrower's broker, then it's not at all obvious that it's a charge for credit then. It's not because it's not a charge for credit required by the lender. There's got to be some new agreement or separate head of agreement between the lender and the borrower as to the payment of the borrower's broker. Now, if we've got an intermediary broker as here, the position is much less clear. But it seems to me that these probably are questions of fact.
Lord,
As to what the facts are here, said Quire.
Lord, I entirely agree with your Lordship's final comments. We do not have complete facts here, but we don't need them. And my answer to my Lord Walker's point, and that's the answer is when I said no to his proposition, it's not how much the borrower is left with in his pocket. It is how much money has been lent for the borrower's purposes. Now, in this case, the borrower gets, as it were, 17,500 in his pocket, but he also borrows £875, which is paid up to discharge an obligation that the borrower has incurred. The obligation happens in this case to be an obligation to the lender who has paid the broker. Query whether it's or not to discharge a debt of the borrowers doesn't really matter. What the debtor has incurred is a debt of £875 to the lender, which is quite over and above the 875, the loan and the interest on the loan. Now, it is as much money, as it were, quotes, in the pockets of the borrower if the money is paid to discharge an obligation to the lender, to discharge an obligation to a third party, or simply handed over in used £50 notes. The result is still the same. The money is being applied for the purpose. Take, for example, a case of a refinancing, where 90% of the money is actually being used to pay off the indebtedness of the borrower to some previous lender.
Well, in fact, in this case, we know that £1,430 was paid to Birmingham Midshire. So it's a detail we needn't be concerned with.
But it emphasises that what matters is not the money that is made, as it were, freely available to the borrower. It's the money that is made available to him either for his own purposes or to discharge his existing obligations. And that, for that purpose, it does not matter whether the obligations are obligations to the person who's lending him the money or obligations to some third party. So what is actually being made available to the Walkers in this case is £835. The fact that the only money that they can actually take away and spend is 17.5, or indeed 17.5 less the payment of their debt to Birmingham Midshires, is neither here nor there. You have to say what money is being provided for them.
No, I
And the
think
money that's
you're
being
at
provided
risk
for
for
is
obvious
clear.
reasons of repeating yourself.
I am,
here,
sorry.
but I just want to be quite clear. The way you're putting it now is really asking us to, is directing attention to the wording of Section 9, subsection 1, isn't it? And what is-
Subsections 1 and 4.
And 4, indeed. What is,
Yes.
So we needn't trouble too much about all the details in the regulations. It really comes down to those provisions which were the centre of the argument in the Court of Appeal, I think.
And where I hope the centre of the argument in our appellant's case.
That's what I thought.
So, my Lord, we have approached it, entirely my fault, perhaps somewhat backwards on, but that is the key. And we say that what you're looking at here, and what you must necessarily look at, is what is the substance of the transaction, and given its substance, does the agreement comply? My Lords, I suspect that, subject to any questions your Lordships may ask, I have, though overrunning by 15 minutes, my allotment, as it were. I hope I have assisted your Lordships.
Thank you very much indeed. Mr. Salter.
My Lords, if I may, one qualification, a very short one.
Yes.
Your Lordships asked at the outset what prescribed terms we say had been breached. Mr. Morey, of course, correctly said it was the amount of the credit. But I wouldn't want your Lordships to overlook paragraph 5, which is the amount of the repayments, for two reasons. It's common ground, it's in Wilson, that they must be correctly stated, if stated at all. But your Lordships will be aware that our secondary argument would bring that into play.
Sorry, paragraph 5.
Paragraph 5 of Schedule 6.
Schedule 6.
Oh, Schedule 6.
Yes,
I'm so
I'm so sorry.
Yes.
And the argument is simply this. If your Lordships were to conclude that in substance, which is what matters, the fee were indeed a charge for credit and not credit in itself, we would then invite your Lordships to say that interest cannot be charged upon it for the reasons we put in our case. Very briefly, I won't repeat it. Firstly, because that would be to treat the fee as credit, the charge as credit, contrary to Section 9.4. Secondly, because it cannot find a home within the TCC regulations, Regulation 4 in particular. It is an animal which isn't recognised. If your Lordships were to accept that argument, that it is a charge and that interest may not be charged upon it, then it would necessarily follow that the repayments had been miscalculated and misstated. So I wouldn't want your Lordships to be under the impression we're not saying that there's a breach of regulation of paragraph 5.
So which paragraphs in the case are we looking at?
It's paragraph 47 and the sections which follow. Page 18, I think, of our case. It's really 47 to the end, to the conclusion, that deal with that subsidiary alternative argument.
And what's the effect of that?
The effect is, my Lord, that if interest cannot be charged upon the fee, then the repayments have been miscalculated.
And what would there be to stop interest being charged on the fee?
Two things. Section 9.4 itself, the charge would thereby have been treated as credit. And secondly, the TCC regulations, Regulation 4, Lord, if we've looked at those in some detail, but if I put it succinctly, it comes to this.
Sorry, this is which tab? Yes, sorry, this is tab 5, yes.
Yes.
Regulation 4, yes.
There isn't a home within 4. This is I think the third of our grounds of appeal. I don't want to repeat it. For interest upon a charge. Because 4A, which specifies what shall be within the TCC, deals with interest upon the credit which may be provided. And we make the point, I don't want to labour it, that it does not say the total of the interest payable under the agreement, which we say it could and should have said had the respondent's case been right. What the respondents answer is, well, interest upon the fee falls within 4B, other charges. And with respect, that's logically unacceptable because it makes 4A completely redundant.
It makes what redundant?
4A,
I
my Lord, because if interest is another charge, whatever that interest be, whether it's interest on the principal or interest on the charge, we don't need 4A. Any kind of interest would then fall within the definition of other charges. And one asks in that situation, what then is the purpose of the TCC regulations? Well, of course, one answer is to identify what charge might, in those days, have taken the principal loan over £25,000. But the other answer, in my respectful submission, is that it recognises an inherent contradiction between the purpose of these regulations, which is to inform the consumer, and the reality of a transaction in which the consumer is not informed and in fact is positively misinformed as to the interest element which is not recognised by these regulations. Your Lordships will remember that in the case of Schedule 1, paragraph 10, again the phrase used is interest upon the credit. And our question, it's not a rhetorical one, is why, if the respondents were right, it didn't say interest payable under the agreement. That would have obviated all possible controversy.
Because there's a difference between interest on the credit and interest on the charge for credit. And interest for on the charge for credit could quite well fall within the phrase other charges, couldn't it?
But that's what the respondents say, and we respectfully disagree, because the same would apply to interest on the credit itself. There would be no need for 4A. The phrase would have been the total of the interest payable under the agreement, just as it would have been in the case of Schedule 1, paragraph 10. That is, it goes further. The prescribed term under Schedule 6, paragraph 4, the rate of interest on the credit, does not say the rate of interest payable under the agreement. The omission is again striking, because the effect is that the lender does not have any obligation to inform the borrower, A, that what interest is being charged on the charges, B, what rate of interest or how much it comes to is payable, or C, the fact that interest is payable at all. Now, of course, that's there in the small print, but as to the required terms, which Parliament required the borrower to know, it is not there. And we assert respectfully there must be a logical reason for that. Now, again, I don't want to take up...
Quite clear, sorry to interrupt you, but you're saying the presence of 4A very clearly set out means that the point that Lord Mance put you can't be right, is that right?
My Lord, yes, that's so.
But if 4A had not been there, 4B would have been broad enough to cover it, wouldn't it?
My Lord, if 4A had not been...
And this may just be a misfortune of what was referred to recently in this court as torrential drafting. Really just trying to cover everything.
No, I accept that, but I go further and say that if that were right, there would be no need for an A, B or C at all. What the regulations would have said, and perhaps I put it crudely, is charges shall include charges and nothing else. The rest of the section, the rest of the regulation is wholly redundant, not to say otiose, supererogatory, and...
Sorry, Mr. Salter, going back to tab 4, the other regulations, the 83 regulations, which one is it that says you've got to set out the charge on credit?
The charge on the credit is paragraph 10. of Schedule 1.
Paragraph 10 of Schedule 1.
Yes. And I'm grateful
Page
that...
3136-6. Or have I got this wrong?
No, that is correct, thank you. Lord, there's a point to be
I'm
made...
sorry, and where does it say that?
Where
Where
it's
does
the
it say?
italics at the top of 3136.
The
The
rate of
total
any-
amount of other charges.
Yes, I see.
But there is a catch that we've referred to in our case. The proviso here applies where any such charge cannot be stated as an amount, and I pause, it can't be because the rate of interest is variable. The rate of the charge or the formula in accordance with which it may be calculated shall be shown separately. Now, it's common ground that the proviso applied here because this agreement had a variable element. And therefore, it was not possible, not even, it was not required, it was not possible for the borrowers to be told what interest was charged upon the broker's fee. Nor were they required to be told that interest was being charged upon the broker's fee.
Sorry, just pausing here. I mean, this argument assumes, for the purposes of paragraph 10, that the 875 is another charge. Is that right?
That is right. It is the alternative case.
And then you say, if it is another charge, then because under the proviso you can't specify exactly how much interest is to be paid, is this it?
That's right.
Then what?
Then the only requirement here is the rate of interest on the credit. So the anomaly arises, and it's transparent.
I'm sorry, the rate of charge, and that's under 2, which is in relation to the other charges.
The rate of charge, my lord, that is right. They simply have to say, as they do, the rate of interest under 1. That is interest on the credit. The charge is stated. The interest upon the charge is not stated.
Well,
and the only requirement...
Surely the words, the rate of the charge or the formula in accordance with which it may be calculated must cover interest, whatever else they may also cover. Don't you think?
Lord, I respectfully agree, except that 10.1 exonerates, exempts the lender from specifying the rate of interest on the fee, if he's able to do it at all. And we say that's why he can't. The fact of the amount of interest and the fact of interest isn't shown on the face of the financial information. The rate of interest, which may or may not be applicable to the fee, is. So, my lords, it is, yes, it's the alternative submission.
And is that covered in Schedule 6 as a, or is that a discretionary matter?
Well, it's... Forgive me, I don't want to mislead anybody. Schedule 6 requires, of course, under 4, it's page 3169, a term stating the rate of any interest on the credit. There's no requirement, and we say the omission is startling, for the rate of any interest on anything else.
Right. So if this alternative argument, which accepts that this is a charge, but then says breach of paragraph 10 of Schedule 1, that then gives rise to a discretion.
My Lord, no, that would not be right, because as has been pointed out, we took that point and we accept that it was rightly decided by the Court of Appeal.
I see.
We did say originally there'd been a breach of Regulation 10. That point is not part of the appeal. My point is, however, that because of that, it makes the injustice the more striking against the consumer, where there is no requirement that he be told, whether as a required or a prescribed term, the fact, still less the rate, of interest upon a charge. And the submission is that that is one reason why it's impossible. But the main reason is that one's thereby treating the interest as credit, contrary to Section 9.4. The answer we heard in the lower court from the respondent was, well, treat should be synonymous with regard or consider. And that, as your lordships know from our written case, is contrary to the ratio of, forgive me, not the ratio, to the arguments in Wilson, where section 9.4 is to be given the widest possible interpretation, we say rightly. So, I'm sorry, I rose to make a small qualification. I'm afraid I've far exceeded that, but I do want your lordships to understand that paragraph 5 of 6 is also very much in play.
Yes. Thank you very much indeed. Well, Mr. Elliott.
My Lord, you have our case. Can I tell you the scheme of my submissions? And, my Lord, when I've told you the scheme, you can then stop me if an area you don't want me to cover. I'm going to first take you to a short factual point, but firstly, I'm going to summarise the respondent's case. I call them the respondents, albeit there's been a change in the identity, but if I refer to them throughout as the respondents, it's only one entity. To summarise the respondent's case in summary, to identify 3 areas where the appellants, we say, have fallacious arguments. Take you briefly again to some of the statutory material. Fourthly, take you to the decisions of the courts which we haven't looked at. Fifthly, to set out our submissions, and our submissions really essentially founded on 12 propositions which I hope will address most of the points that have been raised. That's the course I propose.
Are those in writing, conveniently to be handed down?
No.
No doubt they will be at 2 o'clock.
Well, my Lord, I'm sorry, it's always the way. You do written submissions. They encapsulate what's already in our case, my Lord, but of course one then wants to put something more interesting before your lordships so that try and keep you on your toes by putting 12 propositions.
Well, I hope the propositions are very brief.
Yes. But they are, my Lord, yes. Can I take you to the one factual matter?
Yes.
My Lord, it's in the supplemental bundle which your lordships have, and it's reinforcing simply a point that my Lord Hope made, and indeed Lord Walker made, about what the true amount of money that the borrower wanted to have. And it's page 3 of that. It's the application form. It's in the small supplemental bundle.
Which you described as a supplemental bundle? Oh, yes, the second witness statement.
Yes. It's the exhibit to that I take you to, my Lord. At page 3, the pages...
yes.
This was the first document that was submitted, of course. It's headed application form. It's signed towards the bottom by Mr. and Mrs. Walker on the 15th of April. And the point that I draw to your lordship's attention is the rubric loan details, the second in the black boxes. And what's completed there, loan amount,
Yes.
17,500.
Yes.
That was the amount at the outset that they wanted to borrow.
And this is a Guardian application form?
This is a Guardian application form, and it's attached to forms that they hold, SPPLs, the declaration and consent, and then the money laundering requirement form over the page.
So Guardian seem to have some pre-existing relationship with SPPL.
They certainly have documents.
And but I noticed that on the form on page 3 it says we confirm the information is accurate and that you or any lender to whom you submit this application may use and disclose my data as described in the borrower guide.
Precisely. And of course that 17,500 is tracked through, and the first mention one has of the broker's fee is at page 10, my Lord, which is the security phone check that's carried out as described in Mr. Huff's second witness statement, is that prior to the completion of the agreement on the 22nd of April at page 10, the phone call is made to both Mr. and Mrs. Walker separately, and it has fifth line down, amount borrowed 17,500 and again 17,500, and then under the notes, note 3, confirm with applicant if any fees charged by broker, and then over the page
That's confirmed, charged to whom? to the applicant by the broker.
It's confirmed that there is to be a fee charged. It doesn't explain.
It says confirm with applicant.
Yes, it's
So
confirmed
presumably-
that a fee is payable.
And are these ticks? Well, I suppose...
Those are ticks, yes.
But what are they confirming?
That there is going to be a fee.
But it doesn't tell
Broker fee.
anything about the fee.
Charged by the broker, presumably, to SPPL, because otherwise
doesn't-
otherwise they wouldn't be,
Uh,
they wouldn't be confirming that these were the fees charged.
One has also, of
Well, I'm not
course,
sure whether they're asking the applicant whether any fees are charged by the broker viz his broker.
Well, it's
Just as in 4, they're confirming with the applicant outstanding credit to settle. These are asking the creditor, the applicant, what the position is. At any rate, it's all very obscure, which to my mind is unsatisfactory.
Yeah.
But they already,
I will
they already know the broker's fee, don't they? Because it's
well,
on the
they
next
filled
page.
in the form prior date. That's dated the
On the next page. Yeah.
Where did they get that information?
4. The agreement is signed by the Walkers on the 26th of March, sometime going back to the bundle containing the notice of appeal, tab 5, subtab 6, the agreement itself. That has set out already the broker administration fee of 875.
Sorry, are we in this same bundle?
No, Lord, I'm not, I'm sorry.
The main agreement.
Oh, the main agreement, of course. Yes, yes,
The main
yes, I see.
agreement. I'm
Yes.
sorry that the bundles are
Yes,
set out in that.
Yes.
Sorry, tab 6 is, so there we've got the completed agreement, 26th March 05. The documents we're now looking at are a month later.
Yes, my lord.
These documents are very, very bizarre.
Well,
Page
no,
3.
You have to send an agreement in advance.
Yeah,
a
but
copy
page
of the
3
agreement. When
says
it's a
that-
land, because it's a property agreement, you have to fill in the agreement, send it to them in draft, unsigned by the creditor. It's requirements of the statutory provisions that you have to send copies to them before it's completed.
I follow that, but it's a little odd that it should be before the application form is filled in on page 3.
Yes, it is. It is it's strange.
I repeat my point.
Yes.
It's very, very bizarre. We
It
know
is
very,
bizarre.
very little about it. We know nothing
No.
about the broker's fee except we know very, very little about the whole thing as far as I can see.
But I see that the lenders sign on the 20th of April.
Yes.
Which is actually the same date as page 11, 2 days before page 10.
Yes.
Yes. Well, it's the same on page 11, same date. So that's the 20th of April on page 11.
Yes.
I mean, page 11 is an SPPL internal
Internal
doc.
document is entirely
So
internal
that
document.
doesn't tell us anything about the broker fee except
No.
there is one.
There is one. I'll come back to deal with your lordship's concern in due course, my lord, about whether it matters, because we say it matters not one jot, when one looks at the regulations as to whether or not it's payable by the borrowers or payable by the creditor.
And the registration fee at the bottom of page 11 is an oddity. It doesn't appear
Yes, there's a
anywhere
land
else.
registration fee there.
Yes, whatever it is, it doesn't feature in any
It
part of
doesn't
the
feature.
agreement.
And the £40 fee.
So is that part of the total cost of the credit?
It's not charged to them, no. So, because that's an internal document, it's a fee that has to be carried by the lender and is formed, of course, part of the actual amount that they charge them ultimately by way of interest.
Well, that's as much as we can get out
Yes,
of the
that's as much.
material about the facts.
Can I just summarise the respondent's case? There is essentially only one issue in this case, and that is this agreement irredeemably unenforceable due to the failure to comply with Schedule 6, Paragraph 2 of the agreement regulations? That paragraph requires the agreement to include a term stating, quotes, the amount of credit, close quotes. Nothing more, nothing less. And And so the question that has to be answered in plain and straightforward terms were two questions. A, what is the amount of credit as defined in the Act? B, does the agreement correctly state the amount of credit as defined in the Act? If the answer to B is yes, then the agreement is enforceable. If the answer to B is no, then the agreement is irredeemably unenforceable. In this case, the respondents say, quotes, the amount of credit, close quotes, is 17,500. It's 17,500 because when all the items that constitute the total charge for credit are stripped out of any advance made, then the result is one is left with that sum of 17,500. The broker administration fee of £875, together with the interest arising on that sum, forms part of the total charge for credit. And by reason of the provisions of section 9.4, not credit. That agreement contains on its face a statement saying that the amount of credit is 17,500. Accordingly, the agreement complies with the statutory requirements of the agreement regulations. The form of this agreement is entirely in accordance with the decision of the Court of Appeal in Wilson and First County. We say that decision is correct, and the credit industry has acted on that basis for the last 10 years. There has not been criticism as to the manner in which it has operated or has worked. Well, that's our case in a nutshell. There are three areas, we say, where the appellants have misunderstood and or misapplied the law. Just summarising them, one, it's their construction in relation to section 9.1 and 9.4 of the Consumer Credit Act. We say their construction is wrong. Two, we say that they've misconstrued and put too limited a construction on paragraph 4 of the TCC, that's the total charge for credit regulations, and in particular the words other charges.
In head B.
In 4B.
Yeah.
3, albeit I'm not certain my friend has developed this, but it was apparent in their case, they've misunderstood the manner in which APR is calculated. Next, this is the third heading, my Lord. Can I take you through a rapid gallop through certain of the statutory provisions, pausing from time to time to emphasise certain points? And it's useful, I think, perhaps to start at the beginning, which is the Act. And so if we can turn to tab 1 in the authorities bundle, and could your Lordships put your finger in at top of page 34, top left-hand side, keeping one's finger there. Note this, and turn on to page 51, keeping one's finger at 34.
To page 51,
Yeah, 34 through to 51.
51 being section 20.
Reading section 20, Lord, yes. Lord, I invite your Lordships to do that because that constitutes part 2 of the Consumer Credit Act. Part 2 and all those sections from 8 through to 20 are concerned with defining the terms and concepts that are used elsewhere throughout the Act. Put shortly, and it's doing it, oversimplifying it, it's the definition part of the Act. It's not included in the bundle, but may I invite your Lordship to note the fact it's in our case. The Act also included at section 189 a full definition section of all the terms used in the Act. So far as credit is concerned, Lord, we haven't included, unfortunately, section 189, but so far as 189 is concerned, all that it does is it says for the definition of credit, look back to section 9.
It's a kind of index, really.
It's an index, my lord, yes. But some of them, to be fair, section 189 does include other definitions which are not included.
This Act was the masterpiece of Mr. Benyon when he was a parliamentary draftsman.
It was indeed,
yeah.
and he's written since about defending his legislative abilities, my lord.
Well, masterpiece plainly is arguable, yes.
I think it was called mesmerising by one of your lordships here in Watchtower. Mesmerising, I think. Mesmerising, which will take your lordship to, and I think in Diamond and Lovell it was described as we have to chop through the thickets of the statute in order to pose the simple question. So we have to do that exercise again, my lord, here.
Does he claim responsibility for the regulations as well?
No, and he's critical. In his writings, he's critical of the manner in which the regulations, which, in fact, he's written an article describing the fact that the regulations were not enacted. The statute was passed in 1974. He wrote, I think, to the Times and complaining about...
That's Professor Good.
Professor Good. I think at his instigation.
No, my instigation.
Oh, your instigation. Complaining about that fact. And eventually, in 1980 and 1983, the regulations start to be brought into force. But sorry, but I do an injustice to my own friend, but there was that large gap. Before we get to 9, my lord, can I just draw your attention to 8, because of course the starting point of this is whether or not something is or is not a consumer credit agreement, and that's defined in 8. And what one will see is a personal credit agreement is an agreement between an individual and any other person by which the creditor provides the debtor with credit of any amount. So that's the start of the use of the word credit. That's in broad terms, and then there is a restriction so far as how far the Act applies, because subsection 2, as it then stood, a consumer credit agreement is a personal credit agreement by which the creditor provides the debtor with credit not exceeding £25,000. So immediately one has a restriction. Credit, it's still credit, but so far as the Act is concerned, it's not a consumer credit agreement. And then 3, a consumer credit agreement is a regulated agreement within the meaning of this Act if it is not an agreement, an exempt agreement specified in or under section 16. So there one has credit, and this is a regulated credit agreement because it was under £25,000. But the start of the word credit, of course, appears there. That's defining what, in general, this Act is concerned with. Consumer credit acts, not exempt, they're regulated, they're for under £25,000. Thereafter, I'm going to take you in detail to 9, but one can just see 9 has meaning of credit, 11, restricted use credit and unrestricted use credit. We needn't look at these in any way, but when just tracking through, one can see the heading notes which indicates these are definitions. Debtor credit supplier agreements, 13, debtor credit agreements, 14, credit token agreements, 15, consumer hire agreements, 16, exempt agreements, 16A exempt agreements, 17 small agreements, 18 multiple agreements, 19 linked transactions, and then through to 20. So one sees the scheme of the Act, that this part 2 is there laying the groundwork, as it were, for what all follows in the Act. Can we next then turn to section 9, my lord? You've already been taken to it. Obviously, section 1 is critical. That lays down in broad terms what is meant by credit. in this Act, credit includes a cash loan and any other form of financial accommodation. So that's a very, very broad term. What then the remaining sections do is define in more detail what is credit for the purpose of this Act. It's interesting, we need to look just briefly at 2 and 3 because it illustrates the point that we come to is that credit in fact carries a special meaning within the Act. 2, subsection 2, where credit is provided otherwise than in sterling, it shall be treated for the purposes of this Act as provided in sterling of an equivalent amount. So it immediately has a mechanism here for the Act, which is, of course, the credit's always given in a foreign currency, but for the purpose of this Act, you have to convert the amount of the loan, the credit, into sterling and treat it as that amount. That is because, of course, the 25,000 limit. 3 provides, without prejudice to the generality of subsection 1, the person by whom goods are bailed, or in Scotland hired, to an individual under a hire purchase agreement shall be taken to provide him with a fixed sum credit to finance the transaction of an amount equal to the total price of the goods, less the aggregate of the deposit and the total charges charged for credit. Now, we needn't be concerned with that in its detail, but it's giving there an extended meaning of credit. Because, in fact, no money's been advanced, it's that the goods are being hired or bailed, and, in fact, there is a deposit and total charges for credit which you take out. Again, it illustrates that for the purposes of the Act, there is a specified meaning, a specific meaning for credit. Then 4, and this is the critical section, and it starts with the words, for the purposes of this Act. So as regards common law, or as regards any agreement, it doesn't come with that, but for the purpose of this Act, an item entering into the total charge for credit shall not be treated as a credit, even though time is allowed for its payments. That is dealing fundamentally with the problem where sums are advanced not only as regards the core credit, that's the amount in this instance of 17,500 that the borrower wants to borrow, but incidental charges, document fees, call it what you like, which are also advanced and form part of the financial accommodation. And what it's designed to do is to take out those from within the definition of credit because they form part of the total charge for credit, and therefore it's critical that you distinguish between credit on the one hand and a total charge for credit on the other.
Is the purpose of that provision linked to section 8, subsection 2?
It's linked to both 8.2 and for the purpose of APR, of course, because the definition of APR you include items of total charge for credit. But your Lordship's quite right. Yes.
Yes, I see. Yes, in fact, the note tells us that. I think it says the principal significance is that.
Lord, for what it's worth, this you'll see in subparagraph 2 the words "it shall be treated," which it then forms in negative terms in subparagraph 4, "shall not be treated." That's a phrase, "shall be treated" and "shall not be treated," that appears in other sections in part 2. For your notes, my lord, shall I give you those? It's section 14.4, section 18.2, section 18.3, section 18.4, section 18.5, and section 21A. It's the use of that language, "shall be treated" or "shall not be treated," it is a phraseology that's used throughout, or numbers of instances rather than throughout part 2. Well, I'll come back to make my submissions in relation to 9, but at this stage I'm taking you through the statutory scheme so that you can understand it, but we've already made plain what it is we say the ultimate effect of that is.
Do we get any help from the schedules that are referred to in the footnote?
The examples, no. When you say the schedules, there is the examples 16, 21, and there's others. Regrettably not, my lord. I've looked at all of them, and if we
But we haven't got them.
we haven't got them. We would have brought them. They're dealing with running account credit, credit cards, but there's no example that corresponds to the facts of this case. So sadly not, my lord. And therefore, they haven't been included. They haven't been included because they're not useful, my lord.
Well, we must trust your judgment on that.
Well,
my lord,
if it assists your lordship, I am happy to accept his judgment. Also, the examples in the schedule are not relevant to the questions your lordships have to decide.
They simply cast no possible light on it. Very well.
Sadly,
right,
they
Lord.
really can't, my lord, because they're dealing with completely different
Very well.
forms of credit
Very well.
agreement, unfortunately. Lord, the next section one turns to obviously is section 20. And there, this section, it's headed total charge for credit. What's important to appreciate, of course, is that it's not defining anything. Of course, it's of vital significance when one looks at section 9, and what it does in broad terms, it says the Secretary of State shall make regulations for, and the words that are important, for determining the true cost to the debtor of the credit provided.
Well, you say it's not defining anything. Is it not really doing that?
Well, it's doing it that, but it's not defining what is constituted within total charge for credit.
It's leaving that to
It's
regulation.
leaving that to the regulations.
Yes,
It's defining what it is,
yes.
but then leaving it to the regulations to be more specific.
Yeah.
Your Lordship's quite right, and it's for that reason I emphasise those words. It's those sums. The regulation's got to be made for determining the true cost to the debtor of the credit provided. And so it's got to be what items are in, and also then, and this is the B part, the method of calculating the rate of the total charge credit. That's the APR. Lord, those are the only statutory provisions. Of course, we have all the remaining statutory provisions that you haven't been taken to. That's section 60 onwards, which merely deal with the consequences. But there it's common ground between the parties that if this agreement's non-compliant, what the consequences are. With that in mind, my Lord, can I then turn on to the regulations, and can I start just with the agreement regulations and make just one or two points about that. Your Lordships were taken to paragraph 2, that's at page 3111, that deals with column 2 and schedule 1. Just so that your Lordship should see the scheme, so far as Schedule 6 is concerned, that's picked up at paragraph 6 of these regulations at page 3125. It's headed
Sorry,
signing of...
I'm sorry.
Sorry, Lord,
Just give me the page number.
3125.
Yeah.
This is headed signing of agreement. In point of fact, the consequence of Regulation 6 is it stipulates that those terms that are prescribed terms, if they're not complied with, then it leads to the result that they're irredeemably unenforceable.
Well, I wonder whether this is a convenient point at which to break before we get into the details. Until 2 o'clock.